So as I've said to those who are just joining, we're just holding off for a moment or so until we're good to go. And we now are good to go. So can I again repeat my welcome? Good morning, everyone, and welcome to this webinar, Fit for the Future, Legal Liability in the Post-Paterson Age. My name's Stephen Collier, and I've worked in the healthcare sector for most of my working life, and I still work here. And even in my time, much has changed, and there's much more change to come. Importantly for today's purposes, I was one of the independent advisors to the Paterson Inquiry, and that required me to take an outside-in view of the sector, a sector I've worked in for a long time. Much of what I saw was good, clear, and patient-oriented, but some of it was not. And one area that absolutely was not clear was the responsibility and critically the liability that private hospitals have for consultants who work there. So today's webinar looks to address and hopefully answer three questions. And Jade, if you can give us the slide. And the three questions are the questions that we're going to run with. On the first question, I wrote a short article for Healthcare Markets, which set out a number of commercial and legal changes combining to create change and increase uncertainty. And there's no intention to repeat the detail of that today, but questions on it are welcome through the Q&A function. The second question, is there a fix? Well, that's the nub of what I hope the panel will be able to explore. And the third question, does the sector want to grip this and implement its own solution? Well, that's in your hands. The second part of the webinar, the wider discussion, will allow us all to explore that question. I'd like to begin with a few thanks. Firstly, thank you for joining. Over 200 of you have joined us today. And I'd like to thank the panel formally for the time they've committed to both the preparation and the delivery of this. I'd like to thank LaingBuisson for hosting and the MPS for funding today's event. And I'd also like to thank the individuals working both in the sector and the wider insurance and indemnity sectors for their individual comments and suggestions. And finally, could I just thank Jade Cummings at LaingBuisson for her energy and commitment in getting this webinar to the start line and to making sure it started and it will finish on time. Let me introduce our panel. First, Rob Hendry, the Medical Director at MPS, who brings deep experience of clinical practice, medical indemnity, and med-mal insurance. Second, Kathy Vickery, the General Counsel at HCA, who's a practicing lawyer with a wealth of experience across both the private sector and the NHS. And third, David Hare, who's the go-to person for an assessment of the sector's thinking and the issues facing it. Each of the panelists is here talking in a personal capacity. The structure we'll use today is essentially overview, panel assessment, and then a wider discussion involving you. And that's your turn to explore the issues and the potential solutions. And please do make good use of the Q&A function to ask your questions. So that's the running order. And what I'm going to do is just put up one slide to set the scene. I've got 6 bullet points, and I'll just talk through those. Firstly, I think it's important to be clear about what this webinar is not about. It's not about the Paterson case. It's not about one defence organisation in particular. And it's not about one private hospital group in particular. It's not about the detailed scope and wording of insurance policy or medical indemnity products, nor the extent of any criminal acts exclusion. It's not about aggregate individual occurrence limits, nor the impact of deductibles, and it's not about regulated insurance contracts against medical indemnity. What it is about, and Jade, if you just take us through, it's about 3 things. Firstly, patients, who, if they come to harm, may well find themselves not knowing who is responsible, and from that, who is liable. So they don't know where to go for recompense. Second, even when they, or more likely their lawyers, think they know, there's always a degree of unpredictability unpredictability about that, and therefore a tendency to go everywhere to every potential party, and thereby secure huge costs which bite deep into any compensation. The third element today is the unpredictability of more recent legal cases that increasingly cut through the traditional ways that liability is assessed and framed. Now, this isn't a new situation that we face alone. Other jurisdictions have faced it and come up with very different answer. And Jade, if you flip forward a little, let's just talk about how other jurisdictions have addressed this. In the US, the response has been for hospitals to step forward, generally on a voluntary basis, and take on the primary responsibility and liability when facing patients, but to ask or require consultants as a condition of their practice to have separate insurance in place or co-contribute to the cost up to an agreed level. If the patient suffers harm, generally the recourse is managed by the hospital, and then off stage, the consultant would either contribute or pay up to the level of cover they've purchased. Now, this is sometimes called Harvard model structure, and generally only operates on a four walls basis. That is, within the hospital or system that's buying the primary insurance cover. We've got some real experts on this in the audience. And so while I'm giving you a broad summary, they'll be able to provide a more detailed exposition if required. If we look at Europe, the situation there is that generally civil law systems impose primary responsibility and liability on the hospital as the assembler of the pathway. This is referred to as central liability and has overtones of some of the characteristics that our Supreme Court has been considering in recent cases. Again, the hospital or chain has, by law, the legal liability, and how it seeks co-contribution from the consultant doesn't need to concern the patient. And then we turn to the UK. In the UK, the private sector has generally sorted out the liability question for employed consultants and for NHS caseload. But the gap that remains, and the one we're focused on today, is the situation where a patient suffers harm where the consultant is not an employee. Who should the patient direct themselves to? Some med-mad policies sidestep this by writing cover where the private hospital is legally liable to pay. So in other words, the insurance works where the hospital is legally liable. But the challenge that creates is that only a court of law can give a definitive answer on whether in any particular circumstances the hospital is legally liable to pay. And that forces parties back into litigation just to get certainty. So look, that brings us to the last two bullets on this slide, Jade. Firstly, any resolution will need a sector-wide approach. And second, the sector could wait for regulators or government to impose some form of resolution, or it could take the initiative and design something that works. And I think that's the challenge we really face. So look, let's ask the panel for their views on that and where they think we should be heading. So Rob, over to you for the liability insurer's view.
Thank you, Stephen, and good morning, everyone. It's a pleasure to join you. My name's Rob Hendry. I'm the Medical Director at MPS. And at MPS and MPS Partnerships, we've obviously been giving this situation quite a lot of thought recently, and I'd just like to share some of our views there. And perhaps to stimulate debate, I'd like you to consider the following scenario. Mr. X is a well-respected orthopedic surgeon. He's had admitting rights at Hospital Y for many years, and he carries his own insurance or an indemnity policy. He gets his annual certificate checked by the hospital every year, but during 1 year, he moves his house, moves bank, and for some reason his direct debits are declined, and he doesn't get the various warning letters from his bank and his insurer or indemnifier, and his cover is cancelled. Now, Hospital Y is offering hip revision packages, and a Mrs. Z comes along, avails herself of one of these packages with Mr. X operating. Sadly, things go wrong. She requires further treatment, but she's left with significant disability, and she decides to sue for negligence, and proceedings are issued against both the surgeon and the hospital. Hospital-wide, solicitors contact Mr. X's insurer or indemnifier, but discover that he has no active cover. Mr. X is referred to the GMC, he loses admitting rights, and it all gets a bit difficult. The case is settled, and Hospital Y attempts to recoup costs from Mr. X personally. This causes delay, frustration, and adds to costs for everyone. And this slide illustrates some of the typical costs that might be associated with such a case. So if I could just have the next slide, Jay. What does this then tell us about our current model? And I put up here two slightly stylized scenarios. And in the first, the current model, because risk carrying is protected in silos, when something goes wrong, we often wait for a complaint or claim to come in. And when it does, much of the focus is around liability and apportioning blame. This is obviously an adversarial process, and rather than trying to understand what's gone wrong, one can get into protracted debates about where the liabilities lie, and indeed, sometimes these disputes can end up in court. The patient tends to be lost in the whole process, and the case can take a long time to resolve. So is there a better way? Well, we've been looking and thinking about this, and here's a slightly idealized model on the second part of the flow chart, where the first priority when something has gone wrong is about delivering a timely and satisfactory outcome for the patient. That may include some financial compensation, but also about learning and trying to look at what's gone wrong so that action can be taken to prevent similar problems occurring in the future. Now, that obviously could lead to improved patient outcomes, and in turn, if there are fewer adverse events taking place, clearly that could improve the financial performance of the organization delivering care. Now, we suspect that really this can only be achieved by having some sort of single source solution. And at MPS, we could do this now, either by ensuring the entire organization, doctors, the allied healthcare professionals, and support staff, along with others involved under one med-mal insurance policy through healthcare protection, or the organization could be insured together with allied healthcare professional and support staff under healthcare protection, and bringing together a group scheme for doctors. There's obviously efficiencies there in not having to liaise with multiple different companies. And the other key thing, I think, is that it allows risk management to be put at the heart of such a system to ensure that there is proper learning and improvement as a part of this. And I would suggest that this could give faster resolution, more focused, more patient-focused approaches, and can contain costs for the organization. And you'll notice Cognitive Institute mentioned there, that is part of the MPS partnership family, and we would look to put this in to the part of the solution. If I could just go to the next slide, please, Jade, which summarizes what we would see and what I'm suggesting is one solution to the issues we're discussing today, that having some sort of joined up protection would be a good way forward, with three core services there, both from the individual clinicians, indemnity, a med-mal insurance, but organization-wide learning and training. This would help improve relationships between providers and consultants, because it would avoid adversarial discussions where things have gone wrong. It would also reduce the administrative burden on organizations trying to satisfy themselves that people are adequately insured or indemnified. And it brings together risk prevention and risk management, which would give the consultants a reason to buy into that. Patients also, I think, would have an improved experience, and clearly in a competitive market, it's important both for healthcare organisations and those paying for it, perhaps private insurers, that there is an adequate and good patient care. Multiple factors lead into long-term premium pricing, but one of the factors would be if we could reduce adverse incidents, that may lead to some lower costs of indemnity and insurance in the future. And there's no doubt that the evidence seems to be that early intervention and early settlement can reduce the cost of claims. And lastly, as I've mentioned, the importance of having confidence with other business partners who are involved in the chain of healthcare, I think would be improved by it. That's really all I've got to say at this stage. Obviously, this has been a very high-level oversight of some of the developments we're thinking about and suggesting as a solution. And obviously, we'd be very happy to get engaged in a conversation with people if they'd like to discuss these things further. Thank you.
Great, Rob. Thank you very much for that, and some real creative thought about how this might be addressed. I think it would be good then if we could go to a provider side view. And Kathy, can I ask you for your reflections on that and your sense of what the issues are and how they're likely to shape up in the future and what the sector should be doing about it?
Thank you, Stephen. I've grouped my perspectives really into three main areas, and apologies because I am at risk of sounding like a crass movie trailer, but I separated those into easy, complicated, and downright horrid. So taking the easy first of all, a patient needs to see a specialist and they choose to go to see a specialist in their local NHS hospital, or they go private and opt to see a specialist in a private hospital. So that's the easy bit. We then turn to the complicated bit. Behind the scenes, there are different access routes, which primarily relate to how the patient's trip to the hospital, as it were, is funded. So a patient may end up at a private hospital, nonetheless funded as an NHS patient. They may have private medical insurance. That may be something that they pay for themselves, or it may be something that they have through their employer. They may opt to pay for themselves, or they may have someone paying for them, for example, an embassy for an international patient. When they get to the hospital, unbeknown to them generally, they may be following a pathway which has been developed by that hospital, probably in consultation with doctors, which sets out the length of stay that patient might have should they require an overnight stay, and the type of prosthesis or a basket of prostheses that might be used if that's what their procedure involves. Other hospitals, and particularly depending upon the funding model, may not dictate or direct consultants to use that pathway in quite the same way. There are also different engagement models for consultants. So some hospitals employ some consultants, some employ a number, some employ very few, some employ none. There's something called practicing privileges, a concept very familiar to those working in the sector, less familiar to those working outside, and a complete mystery, I suspect, to patients. Essentially, it's a license to be able to work at that hospital. Or a consultant could be at that private hospital as part of their NHS employment. And that's something we've seen increasingly over the last year, where the private sector and the NHS were working together as part of our COVID-19 response. And in all of those instances, there are different insurance and indemnity arrangements between the consultant and the hospital. And this really reflects back exactly what Rob and Stephen have talked about earlier. It's really complicated. So then the downright horrid, something goes wrong with that patient's care. And the patient ends up hopefully taking some legal advice and navigating between different claims processes and different providers with their lawyers' support. And the policies that attract to each of these are different. Some may be discretionary, some may be contractual. There are different levels of deductible, which at times will dictate who manages that particular claim. It could be that a hospital group has a high deductible and they manage it rather than having to pass it out to their insurer. And there are different limits of liability. Some of the particularly medical defence organisations offer unlimited liability, and some, particularly insurance contracts, are capped. So I make three observations unrelated to those previous points, but which I think are incredibly relevant. What was really clear to me when reading the Paterson report were the quotes that were pulled out from a number of the hospital providers. And I add to that my own experience. Hospitals do want to do the right thing for their patients. They recognise this is a really difficult area. The issues of non-delegable duty of care and vicarious liability chunter on in the courts. And in my view, it's clear the courts at times use legal gymnastics to try to find the right solution for the patient. My third observation is that the Care Quality Commission, the regulator in this area, doesn't differentiate between the different models of consultant engagement. A consultant working at a private hospital is a consultant. It doesn't matter if they've got there under practicing privileges, if they're employed, if they're on secondment from the NHS. They expect us to do the same checks in relation to that consultant. I then have five views, I suppose. And what's key on all of this is that patients need absolutely to remain at the core. I don't think improved information for patients about the different types of relationships between consultants and hospital groups is going to resolve it. I think it's really complicated. We only have to look at how many healthcare lawyers there are in the world to know that. I personally think unregulated discretionary cover has had its time. I think it's been fantastic in the past, but the instances where the cover is being, or the provider is exercising discretion effectively to pull it, are becoming more frequent, and that's often at a time when patients need it most. I don't think that the medical insurance bureau type approach, which has been proposed, is going to fix it. It moves the responsibility sideways, in my view, rather than addressing it head on. Requiring hospitals and consultants to have the same insurer addresses some issues in terms of a single point of contact, but there are a number of other points that would need to be worked through. Conflicts of interest would need to be managed. This is the he said, she said kind of thing. Deductibles and limits of liability would need to be worked through. And ultimately, irrespective of the desire in the sector to do the right thing and to work together, and that's clearly something we're going to come on to talk about, I think we're going to need a layer of legislative or regulator framework to make it happen, to ensure a level playing field across primary care providers where appropriate, acute care, and also NHS private patient units. The other big question is, how's it all going to be funded? I don't think it's right that burden falls solely on the hospital groups. And Stephen, I was going to stop there.
It's a good place to stop, Kathy. I mean, really, really illuminating, and some quite interesting differences open up between yourself and Rob in the way you'd approach it, but probably not where you actually would take it. Before we open the Q&A up, let's just go to David for almost a sector perspective on this. David, from where you sit, what do you see as the issues and potentially the way forward?
Stephen, and also nice to join everyone, and thanks to you for a really sort of stimulating piece in healthcare markets, which I think is really helping to move thinking forward. The question I guess I've been tasked with there is sort of how big an issue is this for the sector, and I'll sort of interrogate both of those. So clearly, as an issue, it is a significant one from the perspective of ensuring that there is absolute clarity for patients about that they will get recourse where there are issues. However, having said that, that needs to be placed in a much wider context of the relationship between consultants and providers, the way in which we ensure good clinical governance in the sector, and so on and so forth. And of course, even defining the sector is something of a challenge in this context as well, because there are so many multiple actors that have a important role to play in moving things forward. So I think from a sector perspective, and hopefully those on the call will have observed in recent times that the sort of particularly the private hospital sector has worked incredibly collaboratively, both I think in terms of the response to some of the issues that have been questions that have been put to it over recent years, but obviously also in the COVID-19 response. And I think therefore you see a sector that is determined to work collaboratively in the best interest of patients. I think when we come at this, I think there are sort of two principles that the whole of the sector can align around. So first of all, there is no competition on safety, and therefore I think collaboration, working together and ensuring best interest of consumers and patients is the right thing to do, working together. And of course, where there are significant incidents, and I know we're not talking specifically through this webinar about the specifics of Paterson, but equally I don't think we can duck the origins of some of those conversations. Often what we see is a sort of whole system failure in those contexts, and therefore it needs a whole system solution. So that's sort of, I get the broad principles of where we come at this from. Clearly, over the last 20 years, there's been significant changes in the way in which the regulation of the market functions. I remember, 15, 20 years ago, the debate was about, whether there should be separate regulatory systems between the NHS and the private sector. Thankfully, that hasn't happened. We've moved away from that into a single regulatory system. And as Kathy, I think, rightly points out, as far as the CQC is concerned, providers are responsible for both for the directly employed individuals that work within their sites and organisations, and for those engaged individuals, i.e. practicing privileges as well. And I think that's absolutely right. When we've come at the really complex set of issues that surround this, I think where we chose to start as an industry that discussion, it links back to the King's Fund sort of three lines of defence. First of all, professionals, secondly, providers, sort of thirdly, regulators, is wanting to make sure that the link between the provider and the consultant is as robust as it possibly can be. And I'm sure many of you will be familiar with the development of the Medical Practitioners Assurance Framework, which looked to set out some of that sort of consensus view of expected practice, which everybody should be shooting for who works in the sector. Good engagement, good dialogue with consultants through that process, and looking at, for example, ward-to-board clinical governance structures with some minimum requirements laid down in the MPAF, greater standardisation over scope of practice and the way in which PPs are monitored and observed, greater definition of the role of the Medical Advisory Committee, ensuring compliance with data submission processes, including those to FIN, and also good processes in key areas such as freedom to speak up guardians as well. And I think why I sort of say that is that clearly we need to deal with, I'll come on to it in a second, the issues around liability and when things go wrong, but actually we need to get upstream of that and ensure that we significantly reduce the chances of that to reduce those numbers, so that actually what we're seeing is high quality governance, good relationships between consultants and providers, so that actually that backstop provision is used as sparingly as it can be. Clearly more work to do on that, and we know there's more to do, particularly once the government responds to the Paterson case around things like the single repository of data and information around consultants, and that's something we are looking at as a sector. So in terms of the specifics, I think around kind of when things go wrong, I agree entirely with Kathy on the point around discretion. I do think discretion has served consultants well over many years, and I think a lot of what the MDOs have done has been very, very effective. I think, however, we do need to close that gap, and whether that is a sort of assigned risk pool or other solutions, I think we have to be willing to look at that. I think if we don't, it'll be imposed upon us anyway, frankly. And then, I think similar to Kathy, I think we probably are looking at collaborative working around a regulatory framework. Some of the discussion today has been framed around, we mustn't wait for regulators to act. Equally, I don't think we can do this without government, where appropriate, being able to take those decisions that none of the rest of us can. So really what I'm looking forward to over the course of the next few months is let's bring together the varying voices on this. Clearly we have a role as a sector, but it isn't an independent sector hospital's sort of responsibility solely to sort this challenge out. Let's bring the right parties around the table. Let's have a look at what some of those solutions are, and as Rob described, really try and streamline and simplify some of that. So as far as the patient is concerned, what goes on under the bonnet isn't an issue for them, and we collectively endeavour to sort this particular challenge out. So I'll leave it there, Stephen, and then good to get into discussion.
Okay, really helpful, David, and thanks very much for that. And actually, I'm left with the words we'll have to get together as a sector to sort this out, look at it. And I'm not suggesting you put that as an offer, but actually you are well placed to begin to develop some solutions for this. I think there are two issues that are starting to emerge in the chat room. One is, and really it picks up points that both David and Kathy have made, which is where is discretionary cover likely to go? And that's been asked in a number of ways. And the other theme is how would this type of wraparound single pane of glass, single point of contact arrangement that Rob isolated work in practice? And people are identifying some of the challenges of that, particularly where consultants move across different hospitals. I'm going to suggest we take them in that order. And Rob, can I turn to you and other panelists? Perhaps put your cameras and your sound on now. But Rob, can we start with you just to reflect on the point Kathy made? Discretion has served the medical profession well over time. It's clearly different from insurance, as a number of people in the chat room and the Q&A have made clear. It's not contractual by nature, it's indemnity. There's not an ombudsman sitting behind it, and it's not regulated in the same way that an insurance contract is, and it has a discretionary element rather than contractual element. So the first question I think, Rob, for you is do you see a future for indemnity? And if so, what does that future look like? So just taking indemnity on its own at this point.
Yeah, I think a really interesting point, and one that we've obviously thought and discussed a lot, because I think, as Kathy says, it has worked well in the past. It gave flexibility to the MDOs to address sometimes slightly unusual situations. And I think, it's largely been used to the benefit of both the doctors and patients. However, I think you're right, the world's changing. Clearly, the government have got discussion documents out about the future of medical indemnity. We'll have to wait and see what that says, but I suspect we're living in an era where regulation and so forth will come in. And I think that's one of the, I suppose, what we've been trying to do, and what I would like to see, I suppose, is the best bits of insurance and the best bits of indemnity, if we could combine that in some way. And really that was what we were thinking about with this more integrated approach, where you would have the confidence of the insurance product, which gives guarantees, and the regulated contractual obligations. So there would be peace of mind, particularly, I suppose, and particularly if you're thinking of both the healthcare organizations that might have doctors with these sorts of cover in place, but also the patients. I can see, though, that there might be some advantage. There was a degree of wraparound discretion for some of the other stuff, again, just to get a little bit of flexibility for both, or at least for all parties, where things that might have been unpredicted and might be in the kind of grey areas on a contractual side. But I think, I think the world is certainly changing. And if we could find some integrated process, that I think would be to everyone's advantage.
And Rob, just to the point about your organisation as a whole, if the world does change, is there still a role for what are currently medical defence organisations? Is there still a future for you?
Yeah, I think in a number of areas. I mean, we've got an insurance capability, so we could offer, if everyone requires an insurance product in whether that's an organization, whether it's individual, that could be done. We're very much focused here on claims and med mal. I think one of the main reasons people join defence organisations is for the wider protection. So probably people worry more about being referred to the regulator, to the GMC, or ending up in front of a coroner, or heaven preserve us, being charged with a criminal offence arising from their professional practice. So I think that goes on. And I think the other thing the MDOs are well placed to do is around the risk prevention, risk management, and educational stuff, because we sit in a lot of information. And that was why we now have, certainly at MPS Partnership, we have the Cognitive Institute, which focuses very much on risk management. Again, working in collaboration, not just with individuals, but with organizations. Because again, I think as David was saying, rather than, could we have a better system that doesn't just focus on apportioning blame, but actually tries to improve care. So I think, we see ourselves very much at the center of the developments in this arena and looking after and protecting patients and organizations.
So there's a good future. All right, Rob, that's kind. And I think you've dealt with a number of the points that have been made about indemnity and the discretion. And I'm going to suggest we move from that to a separate issue. And Kathy, I'm going to come to you. Helen Hartley's asked a very good question. And Helen says, does the panel agree that in a situation where private providers are made liable for care under their roof, and I would say, or where private providers assume responsibility for care under their roof. Does that, Helen says, will it stimulate them to step up clinical governance processes to get higher levels of adherence and compliance? Does it itself represent a quality improving element? Helen observes that that isn't seen as a priority. I'm not sure, Helen, where you are working or where you're seeing it, but I'll let Kathy respond to the point. Does it create the virtue of taking responsibility, assuming responsibility will drive up standards and compliance?
It's a good question. I think the clinical governance processes in hospitals are good. I think there has been learning from the Paterson and each hospital from the Paterson Inquiry and before then. I think each hospital group this is such an area of focus, particularly for the Care Quality Commission. I think what's really difficult, and I'm mindful that in my role as an in-house lawyer, I get to see when things go wrong in a way that the general public don't. And when things go wrong, it may be because a consultant didn't follow a process. It may be because something went wrong. People are humans, things sometimes don't go perfectly. The bit that I feel particularly aggrieved about is when something flips into, for example, a criminal act. When a consultant does something, we've got our policies, we've done everything to make sure the hospital has an excellent clinical governance regime, and nonetheless, for example, a consultant sexually assaults a patient during an examination or performs an unnecessary examination. We have chaperones, we have chaperoning policies, we have notices. And in those instances, it's really difficult to work out, well, what could we have done differently to make this not happen? And it slightly feels like using a sledgehammer to crack a nut. I've said, and it did come out very strongly to me, that hospitals want to do the right thing for the patient, but I do feel aggrieved about picking up responsibility when consultants do something that is so far outside of what they should be doing. And there is the risk that that gets caught up here. And I do not want to end up in a scenario where a hospital group ends up having to be responsible for sexual assaults, as an example.
It's a good example, Kathy, but we're not going to go there, I think.
Can I just come in on that,
David,
one?
please.
Because I think I agree with what Kathy said there. I mean, in my experience, and talking to, frankly, all of the providers over a number of years on this issue, I think the idea that apportioning a different form of liability ups the ante in terms of responsibility for governance and safety in those institutions is not something that I've ever got the sense would have that material shift. Actually, that sense of wanting to deliver the best care in a pretty robust regulatory environment. Actually, frankly, CQC is pretty hot on this stuff. So we can debate where that liability should sit, but I think the principle that if you put it on there directly onto the hospital, that actually that somehow ups the ante in terms of the focus brought to it. I really don't think you can link those two things.
That was much more eloquent than me. I think as well, the other danger is if you do shift the liability, the level of control that hospital groups might need then to exert over consultants would stifle innovation and would stifle different ways of doing things, which we do need. Medicine moves on. So that would be my other concern in that area.
All right, and Kathy, can I ask you something else? Because Peter Streel's asked, I think, a very good question. If the model starts to shift to the contemplation of some type of joint cover, I mean, Rob outlined that, you've talked about it and you amplified that now. Does it restrict the option for consultants as to where they work? I mean, certainly they can't just rock up anywhere now, but does it create restrictions on consultants' ability to work in different providers?
It could do, and I think the model that Rob has talked about needs some thought as to, well, how would it work if a consultant works at numerous locations, which we know does happen. I think my other concern is it does restrict the ability of the provider. So we would have to work through deductibles, limits of liability, and a number of hospital groups or majority of hospital groups don't insure from the ground up. There is a deductible in play there. How does that work? And something that severely compromises a hospital group's ability to make those decisions for itself, depending upon its balance sheet, would need to be very, very carefully thought through. But the operating at multiple hospital sites, I'm not entirely clear how that would work, and perhaps that's something we could pass back to Rob on. Yeah,
Rob, any thoughts?
Yeah, and it's interesting. I mean, we've a number of jurisdictions we work in. This is a recurring issue. I mean, there are solutions. The main problem can be they can be a bit administratively burdensome, which isn't ideal. But I think it does come back to the concept of trying to work in partnership and tailor a specific solution for whether it's a number of hospital groups or whatever, rather than having a one-size-fits-all approach to it. It's not easy. But I think as there is more oversight, as you say, that it extends to some of the clinical governance problems as well, where people are working in multiple places. And actually where we've seen some of the bigger problems, it's where people do work in different places and there isn't adequate information exchange amongst the various management teams if there is an emerging problem. Excuse me. So I think that's probably going to have to be addressed anyway as part of that broader clinical governance issue. So I don't think there's not an easy fix to it, but I don't think it's entirely insuperable.
Okay, Rob, thanks. Alex Caffetz, I have to say, one of the advisors to the Paterson Inquiry, asked a really good question. Assuming we could put this in place, how would we be transparent with patients about who has that primary take responsibility for care? And then the capability, the experience and the outcomes of surgeons treating them, so that the people and patients can understand in advance what their situation is. Just assume we fast forward to that situation, how could we make this clear to patients? Who would need to do what? David, do you want to have a go at that?
It's an excellent question, Alex. And I know from Alex, and I think Alex has been really consistent, I think, on this subject for a number of years, and that relentless focus, I think, on transparency of outcomes and consumer-led change. And I think that's something we should all hold in our minds as we move forward. I think, it is difficult in terms of getting that accurate data, presenting that in a way that's meaningful for patients. I think Finn has done some good work in recent years of drawing in that data. We fully support the direction of travel which Finn and NHS Digital have outlined around the ADAPT programme, which for those who haven't followed it is really an attempt to try to better align the data that is received in for private care services with that which is submitted for NHS care, and actually that has to be the start of a road of patients being able to see outcomes, not just of individual clinicians, but also, you know, in time of providers as well, between the NHS and the private sector. And I think all of us, I'm sure, on this call support the principles of consumer-led change working in a private market, and I think that has to be absolutely the right thing to do. In terms of transparency, I guess there's a number of schools of thought. You know, do you create a market to enable that to get to consumers more directly, to ensure that they can see some of that data? Do you do that through more of a sort of state-led way of doing that? You know, I think that needs further discussion, but that point, Alex, around transparency of outcomes, how things work, you know, we've tried to create some sort of tools and things like that to get out to patients that providers can use. I think that helps, but as Kathy said earlier, it's only part of the picture. You know, we really need to keep pushing on this principle of transparency and consumer-led change in healthcare, which actually there's a danger has sort of dropped off a little bit in recent years.
David, that's really helpful. Taking that as a bit of an action to come back to everybody with. There's a really good question from Eddie Challoner, and Rob, I think it genuinely is one for you. Eddie says, is this whole debate a stalking horse for the demise of the independent medical practitioner? I mean, I've got my own view, but I'd be really interested in yours.
It's fascinating, and I know I've been to a number of these seminars where we've talked about the changing relationships between consultants and the private providers and so forth. I do think the relationship will be changing over time. I mean, it has changed, hasn't it? When already the days, the kind of Sir Lancelot Spratt days, where consultants just sort of, as you say, rocked up at a local hospital and, you know, just assumed they could practice pretty much in any way they wished. I mean, those days have gone as proper governance has come in, oversight of admitting privileges and so forth. So that's, you know, it is changing. And I think, and it'll be interesting just to see how it continues to change and how the relationship between consultants' contracts with the NHS, how they interact with the private sector, how they gain and maintain those rights change. And I know there's been questions about, is that looking more like an employed model? Does that have IR35 implications and so forth? But I think for younger consultants coming along, it would be wrong to think that in 20 or 30 years' time, the model will look exactly the same as it does today.
Okay, so change is coming.
I think so.
Quite an interesting question. If hospitals start to assume that primary responsibility to patients, is it going to drive more consultants into an employed engagement model with hospitals? And Kathy, I'm going to come to you on this one. Is the solution going to drive a change in the relationship so that, in effect, we sidestep all the questions about liability coming through, status, pathways, that consultants simply become employees, albeit on a sessional basis? Do you think that's going to happen?
I think, I mean, we've just talked about IR35. I think that is having an impact in the sector, and we are seeing more consultants move on to an employment model, whether that's for their clinical work or whether it's because they provide advisory services as part of a hospital's governance regime. I think actually what impacts the control for hospital groups is more around the type of work and the funding, and hospitals. If a hospital has significant levels of NHS work, for example, a hospital tends to be more prescriptive about how that work is done in order to be efficient and to make the profit on that work. That may include employing that consultant. Conversely, you can employ a consultant and they don't do NHS or work that is quite so pathwayed. It tends to be perhaps less common for some of the sector. It's certainly a question if we are required to be if we are made liable for the consultants, whether employment is an appropriate model. But some consultants don't want to be employed. They want that flexibility.
Can I just come on that as well, Steve? Sorry, just to add to that, because I think this is, clearly the market will drive change in this space and is already beginning to drive change in this space. And this is where also I think it comes down to when we were talking before about how are we defining the sector, who are we defining as the group that needs to come forward with solutions. This absolutely needs dialogue with the NHS as well, because frankly the model that we're sort of describing moving away from, and I think different organizations will take different approaches on that, is driven frankly by the way in which we've decided to set up healthcare in this country. For the vast majority of consultants who do most of their work in the NHS and then work in maybe multiple private providers, actually the current setup supports that. Actually moving to an employed model could create different sort of barriers between the private sector and the NHS that equally we need to manage. So I think these are whole system challenges, not just for the way in which individual private providers decide to engage with consultants.
Okay. A couple of individuals have put questions in the Q&A about, firstly, the mooted change that government's looking at, possibly moving towards no fault compensation, but nonetheless compensation, and a move to a more mediation-led resolution. And Charles Ranabelda cites Sweden, elsewhere in Europe. Were those changes to come forward, would they be supportive? Would they support the type of wraparound responsibility structures that, Rob, you've described, Kathy, you've amplified? Rob, can I come to you on that?
Yeah, I mean, I think, well, two bits there. I think if we talk about the mediated approach, one of the advantages I was hopefully alluding to was if we had a more integrated and joined up approach, it would allow an early resolution with the patient, which is probably a kind of mediated approach, if you like. So rather than waiting until the patient makes the first move to, allege negligence or whatever, usually you've recognized something's not been satisfactory. And I think an early, and it fits in with the duty of candor stuff that I think a lot of organizations are employing. So an early discussion with the patient, and if that means an early degree of compensation, because sometimes financial compensation is entirely appropriate, that would, I think, be more easy to approach if it was the one carrier taking the whole thing. So I think, yes, mediation is the way forward, and it improves the patient experience as well, because I think one of the things that must be really unsatisfactory for a patient, and it reflects badly on the doctor, reflects badly on the private hospital and others, is if the squabbling over liabilities and things are delayed, because most patients don't want to litigate if they can avoid it. So I think that's the first thing. There was mention of no fault compensation. In England, I don't see that coming anytime soon. Others may have other views. I think there are other systems, and interestingly, I've been involved in the Scottish Government discussions who are attracted to some of the more Scandinavian approaches, but I think that's probably a discussion for another day.
Okay, Rob, really helpful. Karen Harrowing, another of the Paterson advisors, asked a very interesting question. I'm going to put it in a slightly different way. She said that whilst waiting for regulation, as Kathy and David both state, is required, and that is true, Kathy, you both advocated a framework of regulation that would help move things along. My question to you, building on Karen's ask, could it be done without regulation? If the sector wanted to make this change, is it something that's achievable and available from existing ways of working? So in other words, is the sector in a position to move this on, should it so choose? And Kathy, I'll start with you and perhaps then turn to Rob.
I think it depends what the lift is. I think we could do better as a sector, and we are good at working together where there's a common goal, to where we're happy that it's not something that competition law means we can't discuss, but trying to make a better experience for patients is something that we could talk about. And certainly I know David is always happy to facilitate those discussions, which provide us a safe home and a good way to communicate out from there. I'm sort of reading through the question. I think the problem is, in order to remain competitive, we'd all want the comfort that everybody was doing the same thing. So when we talked about this internally, and we said, look, if we got to this stage and we said, right, this isn't the right way to progress, and I give as an example. So a lot of us have talked about the discretionary element of medical defence organisation cover. If for whatever reason that continued, and as a sector we thought this isn't fit for purpose, would we all be prepared to put our money where our mouth is and say, right, if consultant A, you continue to be covered by medical defence organisation, would we be prepared to say you're not going to work here until you get insurance? And the problem is we start looking at it and we say, oh, but they could go to X, they could go to Y. And until everybody took the same view, there's always that worry. But we could certainly work on some of the other areas. I think that we would need a regulatory oversight in terms of better information for patients. And I can see there have been a couple of questions and observations around that. We could do better. We could work together as a group on that, I think.
Okay. And I think the message that comes out, Kathy, where there's common interest rather than competitive tension, that happens and can happen. David, I'm very conscious of time. Just hearing what you've heard and seeing what's in Q&A and a number of questions we simply haven't been able to answer. What's your assessment of sector appetite for picking this up and trying to move something forward? Because you're almost uniquely placed to give us a view on that and maybe a thought about where we would need to go with it.
Yeah. So, I mean, I think I come back to the point I made when I started my introductory remarks. I think what I'm sure people on this call will have seen is a sector that's worked incredibly collaboratively in recent times on the safety agenda and on the COVID response agenda. So, I know there is appetite to come together and come forward with common solutions to the whole of this wider agenda. I think what we've seen now in this discussion is a lot of this is quite complicated, and the sector itself even coming together and saying this is what we want to do in and of itself won't satisfy the challenge that is laid down, because this requires partnership working beyond our own borders with insurers, with MDOs, consultant rep bodies and others as well. So, I think clearly we need to continue in lockstep together, working collaboratively. I think the government will expect us to do that. And from a provider perspective, we will lead the charge, but we need to work closely with others as we do that.
Okay, Rob, can I turn to you from an MDO and an insurer perspective? Because I appreciate you bridge both elements of that. Is that something that you think A is important and B should be progressed?
Yeah, I mean, I think absolutely. And I think, as we've said, number of recurring themes, I think, of what we talked about today. Change is coming. We're living in a changing environment. So we have to be able to do that. Collaboration, partnership, I think there has to be closer working. And certainly we, both from the insurance aspect and the discretionary aspect, need to be working closer with both our members, both the doctors, but also with the healthcare providers to make sure that any solutions we're coming up with actually work for them. And then the third thing is about focusing in on the patient care side of it. And I think, as David was saying, the more we can be doing to move upstream to head off these problems, whether that's identifying problem doctors, whether it's identifying the dangerous ways of or systems, the more we can do that together. And I think pooling resources and pulling learning opportunities there would be in everyone's interest.
Yeah, Rob, really appreciate that. I'm hugely conscious of time. I am going to make some closing remarks, and I will try to keep them as brief as possible. So firstly, thank you very much for joining. The slides will be made available. I think Jade's going to try and get them up either the back end of today or certainly by tomorrow. I'd like to thank the panel again for the time they've put into preparing and delivering, LaingBuisson for hosting, MPS for funding. And I'd like to thank all of you for comments, questions, and all of those who contributed ahead of today. And particularly, I'd like to thank Jade. I think what we've heard is a very broad range of questions, observations, and comments prompted by the starting three questions. I think there's a recognition that we need to make change and that change is coming. And I think there's currently a lack of clarity about how we grip this and move it forward. And I don't know what the answer to that is. I think that the commentary we've had from Rob, from Kathy, and from David indicates a strong convergence about making the change happen and the need for a broad framework rather than competitive point scoring between different providers. I think what would be helpful for those of you who are on the webinar is if you could indicate either through Q&A or other follow-on communication how far you think this is a critical issue for the sector and is near or at the top of the list for things that need to be addressed. Certainly when we did the polling as individuals came on to this, there's a strong view this is something that must get fixed, and we've heard the different components within that. That's, I think, where we're going to leave it for today. Thank you again for joining. Really enjoyed all of the work that's gone into it, and I look at all of us and think we can do better. And I think with the momentum that could be created from events like this and follow-on events that other organisations will be running, we may be able to change our cultural approach and our willingness to make that change. Anyway, thank you very much. Thank you all for being here. And Jade, I think that's a good time to close. Thank you again. Bye-bye.
Goodbye.